Good afternoon, everyone. And Tracy, thanks for that terrific introduction. I'm delighted to join my colleagues in this important conversation. And as said, I'm Wade Henderson. I'm president of the Leadership Conference on Civil and Human Rights, a coalition of more than 200 national organizations working to build an America that's as good as its ideals. I'm also the Joseph L. Rao Jr. Professor of Public Interest Law at the University of the District of Columbia, and so I'm especially delighted to be here to talk about the role of the court in looking at the Affordable Care Act. Now, today's topic is not just timely, it's vitally important. You see, as an African-American male, I can expect my life to be about 6 years shorter than that of the average American. That's 6 fewer years of watching my daughters thrive as young women, 6 fewer years of being with my loving wife, and 6 fewer years to be an active participant in the country that I love. If left unaddressed, this disparity means that the 16.5 million black men now living in the United States will lose about 99 million years of productive life. I don't mean to be overly dramatic, yet that simple fact alone demonstrates why the Affordable Care Act is so important in helping to ensure equal opportunity for all Americans. The primary reason for this disparity is that black men, such as myself, are much less likely to have access to health care and insurance, which means higher rates of preventable diseases and death. The demographic reality is clear and not confined to African Americans. Many other groups that collectively make up the majority of the country are at greater risk for health problems and premature death. Tuberculosis strikes Asian Americans at a rate 16 times higher than the general public. Latinos are twice as likely to die from diabetes. Women are 3 times more likely than men to suffer from autoimmune diseases. A significant contributor to these health disparities is unequal access to health insurance and therefore to adequate health care. Though people of color represent 1/3 of all Americans, they make up half of the entire uninsured population. 17 million women in the United States have no health insurance whatsoever, including 1 in 5 women of reproductive age. Millions of Americans with disabilities have no access to needed coverage. Yet in all the discussions about the Affordable Care Act, little tends to be said about the impact on civil and human rights. The ACA makes health insurance and ultimately health care itself more affordable and within reach of the millions of Americans who would otherwise be unable to obtain it. Today, the Leadership Conference is releasing a set of fact sheets available at www.civilrights.org that document these disparities as they pertain to African Americans, Latinos, Asian Pacific Americans, and American Indian Alaska Native communities. That's also why the Leadership Conference has joined in 2 amici briefs in the case pending before the Supreme Court. Now, as you know, the court is considering a number of issues: the constitutionality of the minimum coverage provision, the severability of that provision, and the unconstitutionality of the Medicaid expansion under the spending clause. In the minimum coverage case, the Leadership Conference joined the NAACP, Legal Defense and Educational Fund, and the American Civil Liberties Union in filing an amicus brief with the Supreme Court, arguing that the minimum coverage provision of the Affordable Care Act is clearly constitutional and in fact advances equal opportunity and liberty for millions of disadvantaged Americans. In that brief, we made the following points. The financial burdens of health care are not distributed evenly. Rather, they fall disproportionately on disadvantaged populations, which are more likely to experience high rates of unemployment, to have jobs that do not have health insurance, and to have lower incomes that put higher insurance premiums out of their financial reach. The uninsured often amass significant debt as a result of unforeseen medical expenses, leading to a downward, destabilizing financial spiral, including poor credit, bankruptcy, lost wages, lower annual earnings, and unemployment. These associated effects of being uninsured are more likely to affect racial minorities. The uninsured have higher rates of illness and suffer the effects of lost educational, employment, and other social and civic opportunities. Better health status in childhood is associated with higher incomes, higher wealth, more weeks of work, and higher growth rate in income. Conversely, being uninsured correlates with poor education outcomes, such as failing to graduate from high school or to enroll in college. Primary and secondary prevention are important parts of maintaining a healthy population, but the uninsured are less likely to receive preventive care. Now, by facilitating affordable health care, the Affordable Care Act integrates the uninsured more fully into the life of our nation and helps them to participate on a more equal footing with the rest of society. The ACA will expand potentially life-saving insurance coverage to, as has been noted, 32 million people, including those segments of the population who have had the least access to care. The ACA also makes important investments in disease prevention, critical to reducing the high incidence rates of diabetes, HIV/AIDS, hypertension, obesity, and asthma experienced at higher rates by people of color and other underserved populations. Also under-discussed are the civil and human rights implications of the provision to expand Medicaid. The court's consideration of this provision is historic because throughout the 47-year history of the Medicaid program, Congress has consistently expanded eligibility for low-income children, pregnant mothers, seniors, and people with disabilities without one successful legal challenge at any court level. This expansion focuses on low-income adults. It requires all states that want federal Medicaid funding to set a floor for program eligibility at 133% of the federal poverty level. For some states, this floor is currently so low that it is unconscionable. For parents of dependent children in Florida, for example, it's 58% of the federal poverty level, or about $11,000 for a family of three. In Texas, the cutoff is 26% of poverty, or just under $5,000 a year. In some states, people with no dependent children are ineligible for Medicaid, even if they are literally penniless. So in essence, the plaintiff states led by Florida and Texas are arguing that the federal government's funding for Medicaid is so great that they cannot afford to decline it by disobeying the new expansion requirement. It is this generosity, they argue, that constitutes the new law's unconstitutional coercion. Now, acceptance of this argument could jeopardize future federal funding for health care, education, the environment, civil rights, transportation, and the nation's general welfare. In addition, a number of civil and human rights groups, including the Leadership Conference, filed an amicus brief detailing the international community's concerns about racial disparities in U.S. health care and describing the ways in which the United States government has presented the ACA internationally as a response to those concerns. In this brief, we cite the position taken by the United Nations Committee on the Elimination of Racial Discrimination on racial disparities in U.S. health care. The CERD Committee has noted its concern, and I quote, that a large number of persons belonging to racial, ethnic, and national minorities still remain without health insurance and face numerous obstacles to access to adequate health care and services. We make the following 2 points: that the Medicaid expansion furthers U.S. compliance with its international human rights treaty obligations to ensure quality and access to adequate health care regardless of race, and that Congress intended the Medicaid expansion provision to help alleviate racial disparities in health care access. And finally, during congressional consideration of the Affordable Care Act, the Leadership Conference played a critical role in the enactment of Section 1557. This key provision is designed to prevent discrimination against women, minorities, and underserved populations in insurance, and is a landmark achievement in ensuring the application of federal civil rights protections in the healthcare system. The full implementation of the ACA, particularly Section 1557, holds enormous promise for preventing unfair discrimination and reducing the health disparities that affect many of the most vulnerable people in our country. Copies of these briefs and our fact sheets are available at www.civilrights.org/healthcare/reform. Now, I close with this thought. The Reverend Dr. Martin Luther King Jr. once declared, and I quote, "Of all the forms of inequality, Injustice in healthcare is the most shocking and inhumane, end quote. Now, at the Leadership Conference, we echo Dr. King's sentiments, and we are working along with our colleagues very hard to prevent the court from overturning this important civil rights protection. Thank you.
Thank you. Thank you. Thank you.